The matter of El-Khouri against Government of the United States of America.
Lord Legate will hand down this judgment.
This is an appeal in an extradition case. The United States of America has requested the extradition of the appellant, Mr. El-Khouri, a dual British and Lebanese national living in the United Kingdom, to answer criminal charges in the United States. The extradition request, in essence, accuses Mr. El-Khouri of insider dealing. He is alleged to have made substantial payments to a middleman to obtain confidential inside information about prospective mergers and acquisitions of US companies, and then used this information to trade in securities and make large profits. The middleman is said to have in turn obtained the inside information from two analysts who worked in the London offices of investment banks. Mr. El-Khouri allegedly paid the middleman for the information in cash and benefits, said to have included payments to charter a yacht in Greece, for a ski chalet in France, and on 2 occasions for staying in a hotel in New York. It is not suggested that Mr. El-Khouri ever actually owned any shares in the US companies, but he is alleged to have entered into contracts for difference, which depended for their value on movements in the share prices of the companies. Those contracts were made with a broker in the United Kingdom. It is agreed that if the facts alleged were proved in a court here, Mr. El-Khouri's conduct would amount to an offence of insider dealing under the Criminal Justice Act 1993. He was, in fact, investigated by the Financial Conduct Authority, but they concluded that there was not enough evidence to prosecute him. A request for his extradition was then made by the United States. At his extradition hearing, Mr. El-Khouri argued that his alleged conduct did not constitute an offence for which he could be extradited, because it failed to satisfy a legal requirement known as the double criminality rule. In broad terms, the double criminality rule requires the conduct alleged in the extradition request to constitute a crime under both the law of the foreign state requesting extradition and the law of the state from which extradition is sought. So in this case, the conduct of Mr. El-Khouri would need to constitute a crime under both the law of the United States and the law of the United Kingdom. The basic idea is that a person will not be sent to be prosecuted or imprisoned in another country if what they're accused of doing would not be a crime under our own law. The double criminality rule that applies here is contained in Section 137 of the Extradition Act 2003. The issue on this appeal is about exactly how this rule operates. Section 137 of the Extradition Act, in fact, provides for 2 different tests of double criminality. Which one applies depends on whether the conduct specified in the extradition request occurs in or outside the territory of the foreign state making the request. It is clear from the scheme of Section 137 that the conduct has to be placed in one category or the other. At the extradition hearing in this case, the United States argued that the conduct alleged against Mr. El-Khouri occurred in the United States rather than outside its territory. In making this argument, they relied on a decision of the House of Lords in its former judicial capacity in 2005 in a case called Office of the King's Prosecutor, Brussels, against Kando Armas. In that case, the House of Lords decided that for conduct to count as occurring in the territory of the foreign state, it is not necessary that all of the conduct specified in the extradition request must have occurred within its territory. The case may still fall into that category, even if part of the conduct occurred elsewhere. That was sufficient to decide the issue in the Kando Armas case. However, Lord Hope, in a concurring judgment, also considered whether, for conduct to occur in the territory of the foreign state, the person whose extradition is requested must be physically present within that territory at the time when he did the acts alleged. Lord Hope expressed the view that this is not necessary. The person need not be physically present in the territory. His conduct will be regarded as occurring in the territory of the foreign state, provided that its intended effect was to bring about harm within that territory, irrespective of where the person was when he did the acts in question. Lord Hope based this view on common law rules governing territorial jurisdiction in criminal cases. Relying on these observations of Lord Hope in the case of Kando Armas, the United States has argued that as effects of Mr. El-Khouri's actions were likely to have been felt on US markets, his alleged conduct occurred in the United States. At the extradition hearing, the district judge accepted that argument. On that footing, the relevant test of double criminality was whether the alleged conduct would constitute an offence under UK law if it occurred in the United Kingdom. The district judge concluded that it would. As I've described, most of the alleged conduct did in fact occur in the United Kingdom, and it is agreed that if proved, it would constitute an offence of insider dealing under the UK Criminal Justice Act. The district judge therefore concluded that the test of double criminality was satisfied. The other requirements for extradition were also met, so extradition was ordered. Mr. El-Khouri appealed from that decision to the High Court. The High Court dismissed the appeal, but it nonetheless certified that the case raised a point of law of general public importance, and the Supreme Court granted permission for a further appeal. For reasons given in the judgment handed down this morning, the Supreme Court unanimously allows the appeal, orders the discharge of Mr. El-Khouri, and quashes the order for his extradition. The judgment is given jointly by Lord Lloyd-Jones and myself, Lord Leggatt. We accept that if the conduct alleged in the extradition request was rightly classified as occurring in the territory of the United States, the conclusion reached by the lower courts was correct. But we hold that the conduct was wrongly classified. This is a case in which almost all the acts specified in the extradition request were done outside the territory of the United States, in the United Kingdom. I've explained that the approach adopted by the lower courts was based on observations made by Lord Hope in the case of Kando Armas. Those observations did not form part of the necessary reasoning in that case or affect the result, and appear not to have been based on any argument actually advanced by either party. At the hearing of this appeal, the Supreme Court asked the parties' counsel specifically to address the question whether what was said in Kando Armas about where conduct should be regarded as having taken place was correct. Having had the benefit of written and oral argument on this question, we have come to the clear conclusion that it was not correct. The view was mistaken for three reasons. First, it does not accord with the language used in the Extradition Act. The word conduct is normally and naturally understood to refer to acts done by a person in a particular place, and not to effects felt in that place of acts done somewhere else. Second, the statutory provisions are unworkable if acts done outside the territory of the foreign state are also classified as occurring in that territory because of their intended effects. Third, the view expressed in Kando Armas was based on an assumption that the Extradition Act should be interpreted by reference to the common law rules governing when a UK court has jurisdiction in criminal cases over acts done abroad. That was a wrong assumption. There is no logical reason why those rules should be regarded as being relevant in this entirely different context. We conclude that the only way to make sense of the relevant statutory provisions is to understand the question whether conduct occurred in or outside the territory of the foreign state depends solely on where the physical acts were done, and not on where any effects of those acts, intended or otherwise, were felt. In this case, almost all the acts specified in the extradition request were done in the United Kingdom. The only act which allegedly occurred in the United States was payment for a hotel room in New York, which was one of various benefits said to have been provided by Mr. El-Khouri to the middleman who passed on inside information. But that connection with the United States was a purely incidental detail of the narrative of events. The substance of the alleged criminality, dealing in securities, using inside information, and conspiring with others to do so, occurred in the United Kingdom. This is therefore a plain case where the conduct occurred outside the territory of the foreign state requesting extradition. The test of double criminality, which the court must apply in such a case, is whether, in corresponding circumstances, equivalent conduct would constitute an extraterritorial offence under the law of the United Kingdom. The references to corresponding circumstances and equivalent conduct indicate that the court must construct a mirror image of what in fact occurred by treating all the alleged acts that occurred outside the foreign territory as having occurred outside the United Kingdom, and must then ask whether in those circumstances this equivalent conduct would constitute an offence under UK law. Here the court must therefore assume that all the conduct alleged against Mr. El-Khouri, except for payment of for the hotel room, occurred outside the United Kingdom. The court must then ask whether on this assumption the conduct would constitute an extraterritorial offence under UK law. The answer is that it would not. In particular, the offence of insider dealing under the Criminal Justice Act 1993 is expressly confined to cases where the dealing occurs in the United Kingdom or on a market regulated in the United Kingdom or relying on a professional intermediary in the United Kingdom. On the assumed facts, none of those connections with the United Kingdom would be present. Counsel for the United States also attempted to argue that another criminal offence of money laundering under UK law would be committed on these assumed facts. But the court also rejects that argument as untenable for reasons given in the judgment. It follows that the requirement of double criminality is not satisfied in this case, and the appeal, therefore, succeeds.
The court will now adjourn.